Welcome to Trucking with OIDA. I'm Scott Thompson.
And I'm Ashley Blackford.
Ashley, how are we doing today?
Doing lovely. How are you?
I'm doing just great. I'm doing just great in part because we are about to be less confused.
Yes, that's ideally what happens every day.
That's our goal
that's
here.
Our goal with every
be
interview.
Less confused
to be less
at the end of the day than we were at the beginning of the day.
Yep.
And that will be the goal, I think, and we're going to accomplish this goal, actually, with Aaron Schepler here in just a moment.
Mm-hmm.
He is senior counsel for Husch Blackwell. They're a law firm. He is an attorney. His focus is transportation-related cases, and that will come in handy today because we mentioned, I think last week, that the Supreme Court of the United States has agreed to hear a case that is ultimately probably, maybe, we'll find out from Aaron, but ultimately going to decide whether freight brokers can be held responsible for crashes involving motor carriers that they hire. This is a case the Supreme Court, an issue the Supreme Court has been kind of kicking the can down the road for a while now. They have decided now to hear a case that will ultimately, again, decide what this looks like for brokers and liability cases. Big implications here, big questions, dumb questions from me, but Aaron is going to be able to answer all of them for us and talk about what this looks like moving forward. And let's get right to it. Aaron Schepler, attorney and senior counsel for Husch Blackwell, on the other side of this. So, Aaron, I don't envy you today because we're going to ask you a series of questions here about legal stuff that Ashley and I don't fully understand. So we'll ask you to dumb it down a little bit if you could. But I know you're up to the task. And one reason for that is your background. You specialize in transportation and logistics cases. Let's just talk about you for a little bit here and how you got your start and kind of how this specialty entered your life.
Sure. Well, first of all, thanks for having me today. I really, really appreciate being on. I've been a lawyer for about 26 years now, and started off as a commercial litigator, sort of a general purpose commercial litigator, and eventually, my career took some twists and turns. I was in city government for a number of years, an in-house lawyer for a Phoenix area municipality, and later returned to private practice a number of years ago, and started doing a couple of things that are relevant to what we're going to talk about today. One is, general liability work, defending, personal injury and wrongful death cases, and also the transportation work that you allude to. So today, my practice spans a couple of different areas. One, and they overlap. One is the transportation and logistics type stuff that you're talking about. A lot of cargo disputes, for example. We represent both carriers and brokers primarily in cargo disputes, occasionally shippers and cargo owners, but mostly carriers and brokers, loss, damage, cargo type cases. And also as a part of that is the suite of, as a part of the suite of services that we offer to our clients. I also defend personal injury and wrongful death cases that arise in the transportation context. In other words, cases involving, a load of goods going down the road, it gets in an accident and someone gets hurt or killed. We would represent the both carriers and brokers in those sorts of cases. So that's what I'm doing today. I've been doing that for quite a number of years now, and certainly the issue that we're going to talk about today is near and dear to my heart because it's one that's really critical for both brokers and, to a lesser extent, carriers.
Yeah, and I think that's a great way to frame it and kind of launch us here because there are a number of implications that we're going to get into. I almost don't know where to start with this, and we're talking about broker liability. We're talking about a case that the Supreme Court is now going to consider. Again, I don't really know where to start here because there's so much to unpack, but let's start at the end if we can, and maybe take this a bit of a different way. How big are the implications of this decision that the justices are eventually, in the coming months, going to come to? What are the big implications that we're looking at?
Well, it's really a huge moment for our broker clients and for freight brokers all over the country. The trucking industry is largely governed by federal law, as you know, because Congress has the authority to regulate commerce. And because the carriage of goods crosses state lines, Congress has the authority to regulate that, which is done in a number of ways, including the Federal Aviation Administration Authorization Act. That's a mouthful. F4A, as we call it for short, is one of the statutes that has been that Congress has created. And generally, what it does, it says that federal law the statute preempts state laws that relate to the price, route, or service of brokers and, incidentally, motor carriers. However, there's a safety exception to that statute. It basically says that if the state law relates to safety regulatory authority of a state with respect to motor vehicles, then the statute does not preempt that cause of action. And what that means is when plaintiffs sue freight brokers, they typically are suing under a state law cause of action, like negligence or negligent hiring or something along those lines. And depending on what circuit you're in, what federal circuit court of appeals you're in, what part of the country you're in, broker liability differs. In some parts of the country, those courts have interpreted the safety exception to cover things like personal injury and wrongful death claims against freight brokers. And in other federal circuits, those courts have interpreted the safety exception more narrowly to say that it does not preempt those claims. So what we've got at present, at least, is a kind of a patchwork of different laws in different parts of the country, depending on where you are. If you're a freight broker, you're not really certain what's going to happen in a case like that. You broker a load to a carrier, the carrier gets in an accident, and somebody gets hurt. If you're in the Seventh Circuit, you feel pretty good about your chances of prevailing there because the Seventh Circuit has held that the safety exception does not apply, and therefore a negligence claim against a broker is preempted.
Right.
Or if you're in the Ninth Circuit, for example, which is where I practice quite frequently, the court there has held that the safety exception does apply to those causes of action, and therefore those claims can go forward. And so, many brokers, of course, operate on a national scale, and there's a lot of uncertainty for them in terms of, am I going to be liable for these kinds of injuries or not, depending on where the accident occurs. And so what's at stake here really is uniformity in the application of this law. And, the Supreme Court occasionally steps in situations like this where there's a circuit split, as we call it, where some circuits go one way on a particular significant federal legal issue and some circuits go the other way. And that's what the Supreme Court has opted to do here, is to try to resolve that split. At least that's what we hope they're going to do.
And so depending on what they decide, and we can talk about kind of those particular, possibilities a little bit later on, but what they decide is ultimately going to dictate whether we continue to have that patchwork or whether we have kind of a uniform standard that everybody goes by. Is that right? And that might be my first dumb question. Is that correct?
No. I think it's a great question, and presumably the reason why the Supreme Court has taken up this issue is that because it wants to create some uniformity. Because this is federal law, and because federal law is a national, legal system, uniformity is always encouraged, and that's why Congress passes these laws, and that's the whole reason why they exist, is to create uniformity, so that when we're talking about national commerce, the result that one can expect going to court is always going to be the same. So presumably the Supreme Court is going to say either that claims against freight brokers are preempted under F4A, or they are not. Hopefully the court doesn't leave it more ambiguous.
Mm-hmm.
Presumably the third result could be that the court says, well, it depends on the facts of the case, which would still leave that uncertainty out there. That could occur too. So there are basically three results that could occur.
Right. But ideally we'll get an answer either way on those first two scenarios that you laid out there. Can we talk about the specific case that the justices are looking at here. It's Montgomery versus Caribe Transport. The court has been I think three cases, at least three cases have been kind of presented to the court before, and they have essentially punted on those. This case they are taking up. Can you talk about it in particular, and maybe also why this case in particular they decided to kind of consider when again they pushed a few others off in the past?
Well, let me answer the second question first. I don't think there's anything about this particular case that may have triggered the review. Rather, I think what it is that the court has seen that there's a critical mass of these cases that are coming up, that are percolating through the system, where there are differing results in the different circuits. And we've got two circuits on one side of the split and two circuits on the other. And I think that's probably, why we're seeing this. Talking about the specific facts of the case, this is really all these cases that have been presented to the court have a very similar fact pattern. You've got a plaintiff who, in this case, Mr. Montgomery, was severely injured when his truck was hit by a tractor trailer, apparently while he was on the shoulder of a road in Illinois on a highway. He sued, of course, the driver and the carrier, which one would expect, but also the freight broker that arranged delivery of the shipment. That happened to be C.H. Robinson Worldwide. And the claim there was that the freight broker had either negligently hired the driver and was also, therefore, vicariously liable for their torts, meaning that Mr. Montgomery sought to hold C.H. Robinson liable for what the driver's alleged negligence. And the theory there is typically that because C.H. Robinson brokered the load to the carrier, then the carrier must be C.H. Robinson's agent for purposes of that. So in the trial court, in this particular case, the court sided with C.H. Robinson and said, no, under previous Seventh Circuit precedent, including Yee versus Global Trans, which is a case that came out in 2023, this claim was preempted. And so, therefore, the plaintiff could not move forward with that claim against C.H. Robinson. And then that case went up to the Seventh Circuit, and the Seventh Circuit affirmed that decision, of course, based on Yee. And incidentally, the court rejected the plaintiff's invitation to overrule Yee, which had only been decided, roughly a year or so earlier. So that's that case. But all of them kind of follow that a similar pattern. You've got a person who's injured in a trucking accident, and they basically try to sue everybody up the line. The carrier and the truck driver, of course, are the natural defendants you'd expect, and then they sue the freight broker, in this case, C.H. Robinson. And sometimes you occasionally even see, I've got a case right now where the plaintiff not only sued the truck driver and his employer and the freight broker, but also on a products liability theory, the truck manufacturer and even the dealership that sold the truck. So plaintiffs' attorneys are always looking for creative ways to get more insurance money, more defendants, more pockets into the mix from which they can recover.
Now, we'd mentioned there was cases similar to this before. The Supreme Court has looked at the broker liability issue before, but decided not to hear those cases. What's different about this one this time around?
I don't think it's factually anything different, because factually they all tend to follow the same pattern. I think it's because we've now got 4 circuit courts of appeal that have now weighed in on the issue, and 2 of them go one way and 2 of them go the other way. And I think that's really where we're at. The Ninth Circuit, which covers mostly the Western United States, and the Sixth Circuit, which covers states like Michigan, they've held that these negligent selection claims against brokers are not preempted because they fall within the safety exception. And then on the other hand, you've got the 7th and 11th Circuit going the other way on that. So I think it's just the fact that we've got now 4 circuit courts of appeal in the mix, and that's 4 out of the 13, that's enough for the Supreme Court to say, look, we've got a problem here. We really need to resolve the split.
Let's talk implications here a little bit. I imagine brokers are pretty vocal about this situation for understandable reasons. How are they, I guess, and how have they pushed back on this type of thing, in previous cases? What are they saying right now as this thing heads to the Supreme Court? Kind of just talk about the broker aspect of this and what their, case that they're trying to make is.
Well, obviously this is huge for them because, if they're suddenly in every jurisdiction liable every time they broker a load, or potentially liable every time they broker a load to a carrier when there's an accident and someone is injured, then obviously that's going to have a significant effect on their bottom line. And I can just tell you that my broker clients in every case want me to file a motion to dismiss these claims whenever it's legally appropriate because of that. We're trying to, I guess, sway the law in that direction by creating a critical mass of decisions that go one way or the other. And it's really disheartening for them because it shouldn't. The result of the case shouldn't depend on where it happened. This is a national scheme that Congress has created, and it's just really an unacceptable result from brokers, from the broker's point of view, that the mere fact that it happens in Missouri instead of Wisconsin or Illinois or something really shouldn't make a difference. It should be the same all across the nation, and that's why this decision is so important.
Well, and the other aspect of this, too, is that I imagine that brokers are making the case that, hey, we can't be held liable for every single thing a motor carrier does that's working under us. Obviously, the other side of that argument is, if you're doing business with them, you should know who you're doing business with and, essentially hooking us up with here in this case. That argument, before the justices, before the Supreme Court, do we have any idea about how that's going to play out? What is that going to look like, I suppose, in front of the justices there?
Well, you make a good point because, when a broker sends a load to a carrier, they really have very limited information available to them. They know that the carrier has the appropriate operating authority. They can look at the safety record. They can see whether or not they have insurance, but that's all they have. And they don't get to vet the individual drivers. They don't even know who the driver is. They don't communicate with the driver. They don't control the driver's actions. And frankly, if a driver has a problem and gets into an accident, most of the time that's just something that, statistically, it's just going to happen. And it's not a matter of, for example, the broker is doing an appropriate job of vetting. They're doing an appropriate job. They're using all the information that they have available. They simply cannot predict all the things that could ever happen out on the road. But legally, I'm not sure that I think that will be a factor in the justice's decision because they have to know, and I'm sure this argument is going to be made, that brokers really don't have a lot of control here. And that's part of, the relationship between a broker and a carrier is that of an independent contractor. And what that means, of course, is that although the broker can dictate the ultimate result, get the cargo to X place by X date, they don't dictate the means and manner in which the freight is delivered. And so that lack of control is part of the justification for not subjecting them to liability in these sorts of cases. So that is hugely important.
If it goes the other way, and again, the Supreme Court says that brokers can be held liable in such cases, the implications of that, I would assume, are pretty great in terms of brokers maybe being, I don't know, a little more gun shy on doing business with certain carriers. Have you thought about what that looks like in that scenario where, again, brokers are on the hook for a lot more than they are right now. What does that look like hypothetically?
Well, I think it's a couple of things. One is it's going to change the pricing structure. I think their brokers are going to have to charge more for their services in order to account for that liability. They're going to have to buy a lot more insurance, which is going to be very costly. The cost of doing business obviously is going to go up significantly. And what that means, I think it has an effect on the people who use those services, parties who have goods to ship. And that means probably it would ultimately, because those costs are ultimately passed on to consumers, that probably means that goods transported in interstate commerce are simply going to cost more. That's one thing. Another part of it is going to be how the brokers vet carriers. There's probably going to have to be some perhaps even new, as yet not created system or way of digging even deeper into a carrier's history and safety record, maybe even drilling down to who the drivers are. I don't really know. It's hard to say at this point. It just suffices to say I think it's going to have huge implications if the Supreme Court goes the other way.
Yeah.
I'm curious, any indication which way the court may be leaning?
Well, that's anybody's guess. It's very difficult to read the tea leaves. What I was thinking is that because it chose to take this Seventh Circuit case, and the Seventh Circuit has held that these claims are preempted, and they've done that. There are at least two decisions out of the Seventh Circuit that have gone that way. My belief is that the Supreme Court is going to affirm that decision and that line of cases, and that's why it took the Seventh Circuit case. On the other hand, I guess if it took a Ninth Circuit case and they go the other way, you could speculate perhaps that they wanted to affirm the Ninth Circuit, although the Ninth Circuit gets reversed a lot in the Supreme Court. If they'd taken a Ninth Circuit case, I would think that they were trying to reverse it just because of the way that goes. It's so difficult to tell, but I think that the reasoning, at least, that the Seventh Circuit and the 11th Circuit have employed, which is simply that what brokers do don't have the requisite connection to motor vehicle safety, such that the safety exception should not apply. That reasoning, to me, is very sound. And I think that argument will carry the day. And that's really what this comes down to. The Supreme Court is really interpreting a statute.
And just to be clear, I want to make sure I understand too. So by taking up the Seventh Circuit case, it would seem, if they uphold that brokers are not held liable. Is that right? This, again, falls under the dumb question category, probably. Okay.
No, that's a great question.
So because they're taking up that, if they affirmed it, it would mean that brokers are not liable, right, for what happens with motor carriers and in accidents and what have you.
That is correct.
Okay. So if that is the case, we talked about the implications of whether, if they essentially say that brokers are liable, if they go that route, the one that we just talked about them not being liable, it would seem to me at least that the implications are not quite as widespread as they would be in the other scenario. Is that right?
That's probably true, only because there certainly is already a certain part of the country where, in different circuits, where they're already not liable.
Right.
So I would agree with that. And all it means really is that, personal injury plaintiffs are going to have to direct their claims to, the folks who are, I think, more logically liable for the conduct. I mean, we have to look at what's the conduct. The conduct is negligently operating a truck or a motor vehicle and causing an injury. And typically, you look to the person who's driving the vehicle, operating the vehicle, number one, and number two, his or her employer, typically, if it's a commercial setting. So, I think that to me seems to be the more natural way that these cases should play out. I don't see freight brokers as being kind of a natural defendant in those cases. It always seemed like a reach to me, and hopefully the Supreme Court agrees with that.
Whatever they decide, it's going to be a while, right? I think we're talking 6 months, a year, something like that, before we probably get wind of what they've decided.
That's right. And I'm not sure when. I don't even think that oral arguments are scheduled yet. So The argument will take place, and then a number of months after that, the decision will be issued. So it's going to be a while. However, we all have, everybody who does this kind of work like me, we all have cases that are pending that have this exact issue on the table. And, frankly, I'm hoping that this decision will help me resolve some of those cases in my client's favor.
Yeah, that's interesting. Do those things get put on hold at all? I don't assume that they do while you wait for the Supreme Court to kind of say what they're going to say, or do they?
They could.
Yeah.
That's certainly a motion that you could make in an appropriate case. For example, if let's say I had a few months from now, I had a motion for summary judgment pending on this F4A preemption issue, I might ask the court to stay its ruling, pending the outcome of this case. If it looked like, if, for example, arguments had already taken place in the Supreme Court and it seemed like a decision might be imminent.
Right. Well, yeah, it's interesting, an interesting topic for sure. And as you laid out very well, the implications of what the Supreme Court decides here are going to be felt across the line here, one way or another. Aaron, at one point, I would like to get you back on to talk about autonomous vehicles and autonomous trucks. I think that's something you work on as well.
It is. It's something that we're very passionate about here at Husch Blackwell, my firm, and my partner Julie Maurer is heavily involved in that area, as am I. And I'd love to come on and talk about that sometime. In fact, let's get back together again after the Supreme Court issues its decision in this case, and we can talk about what happens next.
I love it.
Yeah,
that sounds great. Aaron, as we led this thing off, we said we're going to ask a bunch of dumb questions, but thankfully you're able to, break it down for us. And again, I think this is a big case that has big implications, and we appreciate you putting it into focus for us.
Yeah.
Well, thanks so much for having me. It was great talking to you today, and this is an issue again that's near and dear to all of us who do this kind of work. So happy to talk about it anytime.
Today's episode of Trucking with OOIDA was brought to you by a dedicated team of people that includes Jim Fetzer, Tennille Flick, and Kim Boren.
You got thoughts? We'd love to hear them. You can call us at 1-800-324-6856 and leave us a message, or send us an email at podcast@ooida.com, and we might just include it on the show.